Thank you for staying with us. Conversations around this P&ID case started as far back as January of 2010 when Process and Industrial Developments P&ID Limited signed a gas supply and processing agreement, GSPA, with Nigeria to develop a processing plant in Calabar Cross River State, while Rilwani Lukman was the Minister of Petroleum Resources. That was at that time. So over the years, of course, as you know, the case has been legal, has been business, and has been energy sector, depending on who is talking about it. This morning, we have Professor Yemioke, who is a professor of energy and electricity law at the UNILAG. He will tell us which part interests him this morning. Thank you for joining us today.
My pleasure. Thanks for having me.
First of all, how does this come across to you?
I would say sad, very depressing scenario for me as a Nigerian and, of course, as a sector person. It shows clearly that all is not well with the Federal Republic of Nigeria. And particularly so because my sector, energy and electricity sector, is one that is mostly in the news for all kinds of things, less than honorable things. Today you will hear of crude oil swap, you will hear of subsidy scandal. Tomorrow you hear of Malabo oil deal and all kinds of, power IPP stuffs in the power sector. A whole lot of, because money, of course, will naturally change hands. But in the case of P&ID, it's something that is unheard of anywhere in the world. I've been following the case. It shouldn't even have happened in the first instance. When we had the NLNG, it was transparent. We all followed the process. Who was awarded what, who bidded for what. The law was there even to give a kind of incentive and tax holidays. Things were done properly. But in the case of P&ID, shrouded in secrecy, the company had no reputation or track record in the industry of having undertaken such a sensitive project of gas processing. It was arranged under questionable circumstances, and if you follow the narratives, the storyline, the cases, the submissions, and everything that happened in that court, you ask yourself, what kind of country are we running? It goes to show that we, as some of us have been advocating, we need now, if you have a leader that is well-intentioned, ready to do the right thing, is not going to man those agencies, those parastatals and bodies. We need strong leadership in strategic places in this country, and that is why we have this a shame of a scenario called the transaction. And I'm sure we know the facts are there. Of course, the questionable deal was signed in 2010. It ought not to have been signed, because there was even no specific location where the gas project was to be undertaken.
Before that kind of, excuse me, before that kind of deal that, according to you, shouldn't have been signed, was signed, it got as far as the Minister of Petroleum Resources at the time. And there is no way such a thing, I don't think there is any way such a thing would have been signed without the President being in the know. So what do you think transpired that even got us to that point in on January 11, 2010 in the first place?
Okay, deal. underhand deal, shameless deal of certain unconscionable Nigerians who probably were of the erroneous impression that if you are comfortable, you must steal from the poor, because that's stealing from the poor. And the process of appointment, who God appointed, the pedigree of the person or persons appointed, the capability, all have been questioned. And if you listen to what the Honorable Judge says clearly, which shows that all is not well. It says the contract was obtained by fraud. I'm still going to go into the technical aspect of the arbitration thing, because there's another angle to that. It says legal representation did not do their best for Nigeria. That's the first indictment. Legal representation, perhaps not fraudulent, but did not do their best for Nigeria. The judgment also indict politicians and civil servants, says they're culpable because they failed to ensure that the Nigerian state was represented in the arbitration, or properly represented in the arbitration. And the third one was that even if P&ID was not dishonest or fraudulent, the fact remains that Nigeria was compromised. So who compromised Nigeria? Nigerians compromised Nigerians at the stage and levels of contracting. Of course, we all know what happens. The toppings, the fraudulent toppings that we get, and the needless favoritism that often play out in awarding contract, even in appointing people to sensitive offices.
From what you know, and I'm glad that you brought out the angle of what the justice said.
Yeah.
From what you know, before such a thing would even go as far as it went in 2010, which ministries, departments, and agencies of government are supposed or were supposed to be involved? Which persons or officials of government must sign on before it even gets to the point of the minister? If that's something, I mean, from what you know, what should be the proper process?
The buck stops on the table of the president. And that's why some have argued, I'm not of that view anyway. Some have argued that, well, whatever happens in the petroleum sector, then you should hold the president responsible, because we've always had a sitting president being the substantive minister for petroleum resources in Nigeria. So we have Minister of State or petroleum minister of State or special advisor to the president on petroleum resources and all kinds of things. It was a deal perpetrated by powerful cartel. And that wasn't the first time. What I'm saying is, that was not the first time. We have documented history of sensitive, high-profile fraud in the energy and petroleum sector.
No, you're not still answering my Prof.
The president, okay, let me go specific. Okay. The president.
Before he gets to the president, before he gets to that level, I'm almost certain that there are some people,
bureaucracies.
Yes.
Let me be honest with you. Even before procurement, of course, we didn't have the Procurement Act in place then. Those were new development. There is the Department of Petroleum Resources. There's the Department of Gas Processing. They have Environmental Directorate. They have all kinds of directorates at the level of the NNPC. This deal was struck at the level of the NNPC. NNPC was a conflicted entity. Now we're trying to do it right. NNPC was a going concern until recently. NNPC was also a regulator. How can you be a business entity trading in a sector and you are also the regulator? Until we have the new Petroleum Industry Act signed, I will try to unbundle that. So the configuration, the structure of the then NNPC was was kind of susceptible, vulnerable to this kind of fraud because it was a kind of top-down bureaucracy. At the top, the management committee brings somebody, not only in this. Have you heard of a lot of void blocks that were awarded to people of questionable characters, people who really had no feasible business or businesses in Nigeria, companies that had no non-noticeable, known address in the country being awarded void blocks? So it was easier because it was a monopoly from the directorate, the appropriate directorate in the NNPC, to the Minister of State or advisor on petroleum, to the president. Because all other technical details, of course, you know, the buck stops on the table of the boss. NNPC was a kind of powerful monopoly that wasn't efficient then. It's still powerful now, but then I'm sure things will be done differently. But if you look at, okay.
So we'll look at you want to go to the technicalities now?
Yes, we want to go to
before we go there, the issues that you have raised now, it also brings to mind something that the president said. So I want to ask a question along that end. So the president, through a statement, said the landmark judgment proves that nation states will no longer be held hostage by economic conspiracies between private firms and solitarily corrupt officials who conspire to extort and indebt the very nations they swear to defend and protect. Do you see a probe by the federal government? Do you see the federal government initiating any kind of probe, be it at the executive level or the legislature, to find out that what happened at this point? If, as you said, from the judgment, politicians have been indicted, civil servants have been indicted, do you see a probe coming? Do you think there should be a probe by government?
Let me say and confirm that I'm aware that not a probe, investigation had commenced long before now. I know the particular lawyer who represented the Nigerian state in that arbitration had routinely been picked and reporting at the EFCC for questioning. And a lot of revelations had been made. I'm a lawyer myself. I'm not here to indict my colleagues. So, I mean, it's still at the level of investigation. Let's leave it at that. But there are, of course, it would be huge, a serious disservice to the country if there is no probe. Because we need to send appropriate signals, strong signals that you don't get away with this kind of fraud on the nation. It's bad enough that Nigerians are the ones perpetrating this fraud on Nigeria. Because it will be difficult for a foreigner to come and get licenses, approval, this kind of deal, without unholy collusion from the inside by powerful officials. So I expect a fearless, thorough, sincere probe of this shameless deal. It's painted the country bad. There have been cases like that we read, that we researched, but this spotlighted the country in a very bad light. Okay. And not this current administration anyway, but by previous administration. There must be a probe. Nigerians are going to ask questions. You and I'm sure channels will continue to, of course, follow this, because it's not about to die now. The news is not about to die now. So let's now go to the technical aspect of it.
Sorry, if you don't mind. My colleague Maokwe is very interested in this conversation and has a question or two for you. Maokwe, go ahead.
Well, I mean, it'll be interesting to see what probe comes out of it. But, you know, many people will also be wondering safeguards that were put in place. Because before now, there have been questions as to what manner of thoroughness do we apply to investors who want to come and do business in Nigeria. Do we do background checks on who these people are? Do we ask questions of, you know, their reputation before they come into our country? So, I mean, as I think Ayo has highlighted several times, you know, are you also wondering what processes apply when it is that we're looking for international investors to come into our country? Do you think it's high time we had like a set of guidelines to say, yeah, we're looking for investors, but these investors must meet this certain level of criteria before we can even start to have a conversation? Will it be necessary to have that?
Margaret, thank you very much for that question again. We've always had a semblance of rules, regulation, code, procedures to be followed ostensibly by the players. It's not only in the case of the P&ID fraud. We're still asking the same question in the power sector. Companies came and bidded. Who investigated, who went through, who searched and scanned through their papers, who investigated their claims of competence, financial, technical competence, and before those entities were sold to them. The same thing. This P&ID Limited was not even an oil company, not even a gas company, a trading company, having access to this kind of humongous technical contract. Of course, there will be technical partners. Of course, there will be a committee, bid committee or search committee. There will be a committee of sort to look into those kind of data. They're going to look at their papers, who owns the company, what's their track record, do they have technical competence, do they have the financial capability, who's their insurer in case they fail or default. They will have all those things on papers. But I'm not a fan of academic postulations or paper theories. Because you can package it. And the fact is, those entities had been packaged. Those entities had been packaged to appear real, to appear competent, to appear capable of delivering on the mandates, on the contract. But once you scratch the surface, you realize it was kind of an arranged thing, not real. And that's what is playing out now in the entire energy sector, both petroleum, gas, and electricity. Sadly. And we need men and women of strong characters. We need knowledge-based engagement, knowledge-based appointment, knowledge-based structure at every level of governance in Nigeria. This, I will say again, is not about the president. It's about the officials. It's about the bureaucracy. It's about the civil servants. It's about the lawyers, the arbitrators. It's about our own structure, our own bureaucracies, our own institutions. You know, some have argued that we actually don't need African countries should not worry about strong leaders. They should worry about strong institutions, because it's not about the leader, that's an office. It's about those institutions, institutional framework we put in place, manned by people, competent people, honest Nigerians, competent hands, those who are bold, those who are courageous enough to insist on appropriate standards for the country at every level or levels of engagement, particularly in the energy sector. And that's why we're having all these challenges that we're having as a country. What happened in the...
Just one thing, Dr. Pardon me to jump in here. So, interesting points, you know, that you've raised there about some individuals and certain processes, because yes, we also do see that the AFCC has resumed trial of a certain James Nolan, a Brit, who jumped bail on this same matter. So they're going back to him now that he's got to go back and complete that. But there are other loopholes, you know, that about this particular case, because if you look at the history of some of those involved, the Michael Quinn, for instance, if just a simple says, you see certain things that he's been involved in, not just in Nigeria, internationally as well. And so in terms of how or whether or not we did our own due diligence here. Because looking through the timeline of the case, because this same P&ID began arbitration against Nigeria in 2012. We didn't respond until 2014. At some point in 2015, we seem to have agreed an out-of-court settlement of $850 million. Then eventually backtracked. And so just looked a little really muddled. So in terms of what legally should happen next, some of these persons, these portfolio contractors, some of those who are involved locally and internationally, what is the legal process, the next steps, particularly for this kind of matter?
Thank you. Let me do a recap of the legal process that got us to where we are. So after signing the contract had an arbitration clause. When Nigeria supposedly it was argued that Nigeria failed or breached their contract for gas processing, ostensibly awarded to P&ID. So they filed notice of arbitration and they went to sleep. So things happen. Once notice of arbitration is filed, the next thing you do is to start to appoint your own arbitrator. Even in practice, we know a situation in which a litigant will file a suit against yourself and or your company and get somebody in-house who serve him or her the process on behalf of the company. The staff will stamp it, acknowledge receipt, put it under the door, under the lockers, and then give it to the other side. They will now use that to do proof of service. Then the court will say, oh, they've been served. So the court will proceed and judgment will be given against your company. And your company will be wondering, we are not served, we are not represented. What happened? But somebody had colluded in receiving the document and acknowledging service which they use for proof of service. The court will look at it and say, oh, they were served. There is proof of service in the court's file. You now have to be dealing with post-judgment issues. This is what was happened in that case. Of course, they got their home person as the arbitrator. Even at the level of representation, they didn't do what they ought to do. And in arbitration, you see, once an arbitral award is given, you can challenge it from being enforced. So they sought to register it in Nigeria. That was when the Nigerian government woke up. They filed a suit at the federal court, say, oh, no, this one is not enforceable in Nigeria because it was procured by fraud. They were able to prove fraud at the federal court. And they now use the judgment, the ruling of the federal court to stall enforcement in England because Nigeria had global assets. So they could register it and enforce it against Nigeria and in wherever we have assets. You know, so what happened in that case was collusion, pure collusion.
And again, I mean, you said something the other time that there is no way this is going to end anytime soon.
It's not about time.
But you know, this is quite an enlightening conversation that we have had. One thing that I'm just hoping is that names will be mentioned. Certain specific people will be called out and the needful will be done to ensure that this kind of thing doesn't happen again. Because
as Chamberlain also mentioned,
yes,
we need to see through this process.
We have to. That's
because
part of the
it's all now. A number of lawyers are involved. Some individuals are involved. Some people, persons, powerful persons, or not so powerful anymore persons at the level of the old NNPC, and other politicians are involved.
Okay.
So if you scratch very well, then
you already made the point.
Under the,
yes, that it will be a disservice not to probe. I guess the ball is back in the court of the federal government. Thank you so much this morning. Professor Emilke is a professor of energy and electricity law at the University of Lagos. Thank you again for your time this morning.
Thanks for having me.
There's more after this break. Do stay with us.